Good afternoon, and thank you for joining us for the webinar, Layman's Guide to Contract Terms. My name is Ken Hyman, and I'm an account manager with the Meriwether & Williams Insurance Services, a Hub International company. Please be aware that we are recording this webinar so that we can make it available to everyone at a later date. Before we begin, I just want to go over some housekeeping items. Give me a second here and I will pull this up. So if you have a question, please raise your hand or use the chat box to ask your question. The camera should be on during the class period, but please keep your microphone on mute unless you are speaking. Feel free to be an active participant and make sure that the name you have on screen reflects who you are. We will also be conducting a survey following this webinar to gather your comments and improve on future webinars. So you can scan this QR code and we will be sending it out later following the webinar.
The housekeeping deck needs to be up.
Okay, this is the contact information. Can you see this? Okay, good. With our website, our phone number.
No,
Nope,
it's not up.
Okay. Can you see it now?
I can see it.
We can
Okay.
see it.
Can you start it from the beginning?
Yes, I will. Here it goes. Okay, so as I was saying, if you have a question, raise your hand, use the chat box. We'd like to see you on screen and feel free to participate. We will be sending out a survey to gather your input and improve future webinars. This is the survey QR code. Feel free to scan it now and we will make it available to you later. This is our contact information, which we will provide to you once again. Okay. If you are experiencing any technical or audio issues, please reach out to me via the chat box, which is located at the bottom of your screen. If you have any questions at any time throughout the presentation, please type your question in the chat or raise your hand. Also, a brief survey will be sent out shortly after the webinar concludes to gain your input and feedback. As I mentioned, this is really important to us. I'd like to mention that we will make a copy of today's PowerPoint available and a link to the recording after the workshop once we receive your completed survey. Meriwether & Williams Insurance Services, a Hub International company, specializes in technical assistance programs, providing services to small and emerging contractors. Some of those services are educational and training, bonding support, and contract-based financing support. This webinar will focus on contract negotiation and review, legal protection, scope management, payment terms, timelines, deliverables, risk management, dispute resolution, and other contract-related topics. Please allow me to introduce Jennifer Elmore, Project Manager with Meriwether & Williams, a Hub International company. Jennifer has managed Meriwether & Williams San Francisco Contractor Development and Bonding Program for MWIS over the past 10 years. Jennifer has been with Meriwether and Williams for 20 years, serving in the assistance and development of LBE contractors. And with 20 years working in the surety industry, Jennifer brings this expertise to every contractor utilizing the program's resources. Let me call up the presentation. Layman's Guide to Contract Terms. One moment, please. There we go. And please take it away, Jennifer.
Good afternoon. I'm Jennifer Elmore, and I really want to thank everyone for coming on and utilizing this and allowing us to spend this time with you. We really appreciate it. Next slide, please. So of course I have to read the disclaimer. The information provided in this webinar does not and is not intended to constitute legal advice. Instead, all information, content, and materials available are for general informational purposes only and given as a result of Meriwether and Williams, a hub company's experience working with small and emerging contractors. The webinar is not to be construed as a substitute for review by legal counsel and other professional advisors. It is our recommendation that the contractor should have an attorney review all of your contracts. The purpose of this webinar is to give you some insight into your contracts and how contracts affect your relationship with an owner and or prime contractor. Thank you. Next slide, please. So today's objective. So why do we need to review contracts? The purpose of the contract review is to ensure that you are comfortable and understand the legal agreements and the terms, and that legal and financial risk is reduced as far as possible to protect the interests of your business. The contract is perhaps the most important part of a construction project to get right. It is the pathway to a successful project and is in all respects the rule book. Given the complexity of construction contracts and the risk involved, it is important to allocate to best protect your interest when something unexpected occurs. Next slide, please. So this is a checklist and it is not exhaustive, but we always put different parts of the contract into 3 different categories. One is read for accuracy, and then you see the listed underneath. Then there are sections to review to make sure they're either in there or not in there, or to the extent or how they're written. Then there are the sections on the right-hand side that are sections to pay close attention to and how they impact. And most of the ones listed here will on the left, the read for accuracy will always be in your contract. And you need to check for the other sections, and we'll go over during this seminar why they're important. Next slide, please. So when you're reading for accuracy and you're talking about the scope of work, and this is really important for everybody to understand, and let me stop and say, if you have any questions, put in the chat, raise your hand. We can go past a point more closely, and we can make sure that you feel comfortable with what I've been talking about. And this is a really important point. Once a contract is signed, any negotiations or discussions that you had before, if not in the contract, are now null and void. Therefore, it is important to review the scope to make sure that it matches your estimate, scope letter, and discussions that you had with the prime and or owner. What sections should be included in your scope? A scope of work is a written document that outlines what activities are included in your construction project. As part of the contract, it describes the project's objectives, milestones, deliverables, and outcomes. It also outlines the responsibilities of the project team, as well as the terms, conditions, and requirements. Overall, the scope should lay out the owner's expectations for the completed project.
Hello, Jennifer.
Yes,
This is Kenneth Collins. I've been on since 3:01,
yes,
and I was just led into the meeting. So is this the page 2 or?
we are on page 5. But if you would like, if you and I stay on afterwards, I can go over the first part of it. As well as you will receive this video as well as the handouts, if that would help.
Yes,
So,
that'll help. Yes, I
yeah,
can go with myself afterwards. Thank you.
sure. And my number and information will be there for you to contact me if you'd like. But what we're doing is we're reviewing contract terms, just to give a short summary. One for accuracy, another section is to review, and the last one is to pay close attention to. So we're just at the beginning, if that helps.
Thank you.
You're welcome.
Yeah, and this
So-
is Ken. Just briefly, sorry, some people didn't get admitted right away. I apologize for that. And just a reminder too, please mute your microphone unless you are speaking. Thank you.
Okay, all right. So we're now on the scope of work, and we are on the project scope and performance standards. The contract must define the project scope and performance standards with provision. This includes a detailed description of the work to be performed, quality standards, and expected deliverables. Failure to do so can lead to disputes regarding what was initially agreed upon. And once again, I'm going to reiterate, once a contract is signed, any discussions, anything that you, if it is any discussions, any scope, anything that you had in the contract, if it is not part of that contract, it is no longer valid. So you want to always make sure to read the scope of work for accuracy, to make sure everything that you and the owner or the prime contractor agreed upon is in the contract. So one of the sections of a scope of work are in the contract are definitions. And what you're looking for in this is clear wording and terminology, and that should go a long way to minimizing the risk of disputes, claims, and litigations. The scope of work should use terms that everyone understands, including the terms used for each party to the agreement. The construction business, as you all are aware, is rife with industry jargon and abbreviations. Make sure you feel comfortable with those terms and those abbreviations. So in the scope, what you want to do is you want to look at the role of inclusions and exclusions in construction contracts. Inclusions and exclusions are common terms used in construction contracts. Inclusions refer to the items or services that are included in the scope of work, while exclusions refer to the items or services that are not included. And this is where it's important, what you exclude in your scope letter is as important to see in the contract as what you included. So you want to make sure that everything you excluded is also excluded in the final contract. And one of the best ways to do that is make sure that your scope letter is attached to the contract as an exhibit. Okay, so contract amount. Review the contract amount to make sure it matches the amount of your proposal and any agreed upon alternates or change orders. If changes have been made to the scope of work, make sure that changes are reflected in the scope description as well as the contract amount. Milestones and deliverables. This section should detail all the expected project goals that need to be reached through the lifespan of the project. It will ideally include enough relevant information to provide contractors and subs a clear understanding of the project requirements. Scope and technical details will give you essential idea of the tasks and technical aspects. Specific methods and techniques required for the completion of a contractor's performance will be listed, along with the evaluation criteria. Schedule and timeline, not a full detailed construction schedule, but rather a general list of tasks and related tasks for the projects and when they are expected to be completed. Contractors need to plan around their deadlines. To do so, they should be told the overall anticipated project timeline, delivery dates, and any relevant completion milestones. Management and administration, and of course, from my perspective, this is the most important, or the one that I understand the best. This section of the scope of work will define the administrative procedures on the project. How are change orders handled? When and how are payments going to be issued? These questions are ideally answered in this section along with any other pertinent contract and legal requirements. Next page, please. Okay, and we're still in the read for accuracy section. So what's important is documents from a bid package are incorporated into a construction contract. So I can't take a survey, but if you're working predominantly as a subcontractor, this is a really important point. So in terms of when you sign a contract with a prime, all of the owners with the prime's general conditions, supplemental conditions, bid package are all included in your contract. And we'll get into how that works. If there is a conflict between the contract documents and the bid package description on a specific item, the bid package description will often be the prevailing clause. Please be aware if an item is covered in the contract documents, but not in the bid package description, the bidder is still responsible for that line item or item of work. General conditions. The general conditions outline the responsibilities and expectations of project owners and set the framework for how the project will be managed and executed. General conditions act as a rulebook for the execution and management of a construction project. They encompass a broad range of terms that dictate the fundamental procedural guidelines and establish the rights and obligations of the parties involved. Key areas covered by general conditions typically include project administration, the responsibilities of the owner and contractor, guidelines for submittals, procedures for change orders, protocols for payment application. They also lay out requirements for insurance and bonds, provide instructions for conflict resolution, and set terms for potential project termination. Furthermore, general conditions address the contractor's operational scope, including the provision of a site superintendent, project management, the handling of on-site conditions such as security and safety measures, and owner's general conditions also impact subcontractors and lower tier subcontractors through what we'll explain later through flow down provisions that we will discuss later. Specifications and drawings. They're absolutely the technical data and the material requirements, but reviewing the scope of work for a construction project can help avoid mistakes and rework, which can save time and money. It can also help reduce stress on the working relationships by clarifying whose responsibility it is to cover the cost of any corrections, as an example. Next slide, please. Okay, so this is another section that we ask that you read for accuracy. So take note of the method of dispute resolution in the contract that is required. Many contracts stipulate that the parties will go to arbitration if there's a dispute, and you'll see it JAMS or American AMA. Many contracts stipulate that the parties, if there's other options, include mediation or a lawsuit. You'll also want to note who is responsible for, what's important about it is you want to note who is responsible for attorney's fees if a claim is settled or decided by a judge or arbitrator. Also, what's really important is where is the dispute taking place? If your project, and I'm just pulling something out of the air, is in Washington, D.C., but the prime's home office is in Colorado, and the prime requires that the dispute take place in Denver, Colorado, then there is an added cost to that dispute, and you may just not move forward with the dispute because it costs too much. So you want to make sure it is within where you're doing your work. Next slide, please. So now we're reviewing contingency payment clauses. So there are pay when paid versus pay if paid. And you'll want to make sure to check the payment clause. Oh, there's a question.
Yeah, we have a question here. To my understanding, paid when paid or paid if paid on public contracts is illegal in the state of California. Is that your understanding as well?
Well, they're jumping ahead, which is great. Does everyone understand the difference? Let me just ask around. Does everyone understand the difference between pay when paid and pay if paid?
No.
Nope.
No. Okay. So pay when paid is essentially how you're paid, and it puts in a deadline for when payment will be made. So let's say you're a subcontractor, the owner pays the prime, and then within a reasonable amount of time, then you pay, then the prime has to pay you. Now, those reasonable amount of times or that deadline for payment to you are subject to federal and state prompt payment laws to make sure, and then pay if paid is the owner does not pay the prime. So the prime is not obligated to pay you. So in California, as of 2023, and I looked this up, pay if paid clauses are illegal in the following states: California, Delaware, Illinois, Indiana, Kansas, Montana, Nevada, New York, North Carolina, South Carolina, Utah, and Wisconsin. What impacts the pay when paid laws are what they call prompt payment laws. And I'm probably will mention this again. What you can do is you can put your area that you're in and put prompt payment laws into Google, your area, because your state government, your state will have a law on prompt payment, your county will have a law on prompt payment, and your city will have a law on prompt payment. And you can see if that impacts. And so what we always recommend is that if you have a pay if paid, even though it is illegal, when you see it, you should ask the GC to remove the clause because it's illegal. If you have a pay when paid clause, you should alert the GC to the deadlines and the prompt payment laws so they're aware of them. Does that help? Okay. Okay, perfect. All right. Next slide, please. Okay. Termination for convenience, termination for default. These clauses stipulate what happens if the owner prime terminate the project for their own purposes. Often the clause states that contractors will only be paid for work that has been performed or installed after the date of termination. This means that materials or equipment that have been purchased and have not been installed yet are not paid for, and the contractor incurs the cost without reimbursement. Where possible, try to negotiate this clause to include reimbursement for materials and equipment that have been purchased and have not yet been installed. Termination for convenience may be impacted by local state requirements that impact inabilities, owners, primes to remove a prime subcontractor from a project. For example, in some localities, there are local contracting requirements which impede a prime from removing a contractor. Termination for convenience should be a two-way street, allowing the subcontractors to walk away from a project just as the owner prime, so that you can both terminate a contract. Check the contract to make sure it is not one-sided and that it is a mutual, so that you have the ability to leave the project as well. Termination for default is the complete or partial termination of a contract because of a contractor's actual or anticipated failure to meet its contractual obligations. So what we find, what you're reading for here and reviewing is what triggers the termination for default. And what language they have for fixing an issue once they have sent you notice of termination for default. So not meeting, as an example, not meeting the contract timing milestone is often a trigger for primes and owners to attempt to default contractors, as contracts include time is of the essence clauses. That is in every contract, that is without fail. And it means it just expedites the fact that if there are timing issues in the contract, it raises them to default level if you miss milestones. Next slide, please. Oh, did I hear? Okay, no damage for delays. A no damage for delays clause attempts to protect an owner from receiving time-related damage claims from a contractor, or a contractor from receiving a time-related damage from a subcontractor as a result of a delay, even if the owner or prime contractor caused the delay. Often a no damage for delay clause states that a contractor cannot be reimbursed for costs incurred by a delay caused by an upper tier party. For example, a subcontractor cannot claim costs for a delay caused by the owner of the GC. This means that lower tier contractors can lose significant amounts of money waiting for upper tier contractors to move the work along, whether they cause the delay or not. Where possible, negotiate this clause to include the reimbursement for damages if a delay is caused by an upstream party and is not the fault of the contractor. Now, one of the things that's really important to realize is this may be void in California Public Works contracts. And North Carolina law prohibits the use of no damage for delay clauses. So I would ask them to remove the clause. This type of clause is permissible in the state of Texas. For your information on your area, Google no damage for delay clause and type the area to see if it is enforceable or not. Because you don't want them to fund their delays on your contract. Next, termination for convenience. Sorry, I missed that before. Termination for convenience is, for example, when termination for convenience is when a contract no longer is valid. So, for example, one of the termination for convenience we just recently had with a contractor was a landscaper went in to do a project. It was discovered that there was asbestos naturally occurring in the area. They stopped the project and they terminated the contract for convenience because they had to abate the asbestos before they could issue another contract. And the plants and all those items that they didn't want them to purchase them and continue with the contract. They continued it at a later date, but they terminated for convenience. Does that help with an explanation?
Hi, yeah, that does clear it up a little bit. I'm just curious though, on your example, would there be normally something in the contract for a remedy for that sub? I mean, for example, they spent the money for the plants and the contract and the gardening?
So yes, you would negotiate with the prime for the plants that had already been purchased. Yes, there is a remedy for that, and that's why you want, if this situation comes up, you want termination for convenience, because work and supplies already purchased are usually paid for then by the owner. And so that's why you want a termination for convenience instead of a termination for default. Okay. All right. Next slide, please. No, go ahead. Okay. Liquidated damages. Liquidated damages are penalties for completing a project after its scheduled completion date. LDs are assessed to potentially compensate a project owner for lost revenues due to a delay on the project. LDs are usually assessed by the owner to the general contractor, and here's the issue, are often passed down to subcontractors. If there are LDs on a project, make sure that the damages will be passed down only to the contractor responsible for the delay, and that the damages are proportional to the contract amount. LDs are not meant to be a penalty. They're meant to offset a loss if there are delays on a project. So subcontractors are especially impacted by LDs from the owner to the prime because they're passed down with what we call the flow down provisions, which we'll discuss later. And it may, if they're too high, prevent a contractor from receiving a bond.
para televisores de todo type.
It may prevent a contractor from maintaining bonds because the surety company is going to try to
A ver
protect.
si me das mañana o el jueves, si vengo mañana. Vale, pues.
Okay, all right. Next
No,
slide,
no lo puedo
please.
para ahorita, no, para el
Mark-
jueves o si tengo otra mañana.
Hola, no
Sí,
está
silencio, por
mudando.
favor.
Gracias.
Ken, as the
Yeah.
host,
Yes.
you can mute him.
Yes, done.
Okay. Next slide, please. Okay. No lien clause. And this is the reason why we have this is the purpose and the enforceability are important, but we want to make sure that in every contract that you preserve as many rights as you can to protect yourself. Some contracts include clauses that require a contract to waive their lien or bond claim rights before work starts. The waiving party ends up agreeing, whether they know it or not, to perform the work without protection of a potential mechanics lien and or stop notice or bond claim against the property if they end up not getting paid. Does everyone know the difference between a stop notice and a mechanics lien?
No.
Okay,
No.
so if a mechanics lien are on private projects, and that's where you put a lien on the title or the deed. And then stop notices are on public works project, and usually what they do is they go to the entity that pays the general contractors. And they're notified that there is a problem on the project that you have not been paid. So they're one and the same, they just take different avenues because you cannot put a lien on a public works project. So these clauses are generally not enforceable as contracts need to be legal. However, you should be aware of whether or not they can be enforced in the state where your work is. Either way, you should ask to strike the clause as it takes away a legal right you are entitled to. California, North Carolina, and Texas are states where it is prohibited to waive your lien rights. If I did not mention your state, please Google no lien clause and your state to see if it impacts you. Next slide, please. Subordination of lien. Another clause you may find related to lien rights is a subordination of the mechanics lien or stop notice clause. The subordination of a mechanical lien relates to the mechanics lien priority. So that means that it goes under all other rights. Which is what may ultimately determine who gets paid first or at all if there's a default on the project. These clauses often state that the mechanics lien will be placed behind other liens in priority. Being at the end of the priority line can mean that you won't get paid even if you have a valid lien. So see if you can strike this clause as well. Next slide, please. So flow down language. It's also called flow down provision incorporated by reference. Many subcontractor contracts have a clause that states the terms of the prime contract apply to the contract with the subcontractor. These are called flow down clauses. If you find such a clause in your contract, and you will, make sure you request a copy of the prime contract and all the documents, including the general conditions, so you can review them. Since you are agreeing by signing your contract to the terms of the prime contract, you have a right to review those terms. They can obviously redact them for private information, but they have to share them. So contract documents clauses impacted by the flow down provision are general conditions, dispute resolution, and LDs, to name a few. If you are a subcontractor, always request a copy of the general conditions from the prime to truly understand your obligations. There may also be conflicts in the contract documents. If there is a conflict, review the contract to see if there is a clause that addresses the order of precedence or which clause is more important. Usually you'll see a clause that says, if there is a conflict, we take the strictest legal language. If not, have the prime provide clarification before signing of the contract. And I'm going to reiterate, once you've signed a contract, you can't make any changes, or it's extremely difficult to make changes. Next slide, please. Change order language. So what we want to do is make sure you review the change order section, or it's also called claims section. You'll want to know what is the process for submitting changes is, what the notice deadlines are, and the process for filing a claim. And the process for filing a claim if a change is not accepted. If the notice deadlines are too short, negotiate to extend them. So let's say a prime contract states in their contract to a subcontractor that if there's a change, you have 3 days to file it. That doesn't seem sufficient time. See if you can get it up to 5. Additional information on the change orders. What can be included in the change order pricing? What are the allowable markups? What happens if you don't submit timely? Have you waived all your rights to the change order? And then what are the notification requirements to the surety company? When you're working with a surety company or a surety broker, anytime your contract increases by 20%, the surety wants to be notified of that. And then also please note that the Business Recovery Series has an entire seminar on change orders on the Meriwether and Williams Hub Company's YouTube channel. Also, just so you're aware, a lot of public entities have codified what are allowable markups in their contract's general conditions, which is another reason why you want to look at that section in the general conditions from a public entity. Next slide, please. Most construction contracts require contractors to warranty their material and labor for at least 1 year. Review the warranty clauses to make sure there aren't hidden warranty requirements that the owner or general is requesting. Sometimes they may request warranties of 5 or 10 years, depending on the work being provided. Make sure you know how long you have to warranty your work before you start the project. Make sure to review the warranty period in your subcontracts as well as the owner's terms and conditions. If performance and payment bonds are required, surety companies are uncomfortable with providing surety bonds for small and emerging contractors for projects with a warranty for more than a year. If they do provide it more than a year, for example, 2 years, then that will increase the price of their bond. And we want to make sure you're aware of that so that you can include that bid premium, that extra premium for the extra warranty in your estimate. Also, we want to make sure that you review that there are no errors in the contract's specifications, requesting a warranty period of the subcontractor instead of the manufacturer's warranty on the product/supply installed. A while back, we worked with a subcontractor on a project, and it was a painter, and the owner's specifications asked for a 10-year warranty for a specific item, which should have been a manufacturer's warranty. It was an error in the specification, and we worked with the contractor and the public entity to correct the specifications before the subcontractor entered into the contract. Next slide, please. Progress payments. What to review and keep in mind when you're looking through and you're reading these for what information you have and what you should pay attention to. Progress payment cycle and what documents should accompany the progress payment invoice. Are there any forms required by the owner prime to be submitted? Request from owner prime, a sample of the pay application documents if not included in the contract documents. What is the retention that an owner / prime has in the contract? Can you negotiate that amount? So, for example, in oftentimes in California now, a lot of our contractors have been successful negotiating from a 10% retention down to a 5%. What is the timing of the payment? If the owner's payments are delayed, how long do you need to wait? And that goes back to the pay when paid or pay if paid clause. What recourses do you have if the prime does not pay? Usually on government contract, there's some type of contract compliance officer that can assist you in expediting progress payments. So that's something you should look up before you enter into a contract. Also, and this is really important, we've seen this more recently, some prime contractors have a factoring type system in place to advance progress payments. And there's a cost to that. And one of the systems we've been seeing is Textura. So you need to know the cost of it and how much in advance so you can include that information in your bid. Even if it's just a small cost, every little bit adds to profit fade. So we want to make sure that you guys are catching everything in the contract that will impact how well you do on the project. Okay. And then also we want you to look in what recourses do you have in the event of a non-payment of progress payments. And then also look up, and we can send out something afterwards. We do have an overview of the mechanics lien stop notice process that you can then adopt to wherever locality you are. Next word, any questions? Okay, next slide, please. Okay, this one I think is really important. So this is protection of work. Who is responsible? So the risk mitigation for the prime contractor and owner allocating the liability of protection of subcontractors' work product to subcontractor. So what does this mean? They're essentially passing the risk baton to you, and that's not one that you should be responsible for. This clause protects the prime and the owner while a subcontractor is completing their portion on a project. So these clauses usually require that a subcontractor fix anything that goes wrong with the portion of work until the project is completed. What if you've gone in and you are no longer working on the project? Who is responsible for fixing? So if you have negotiating power on your contract, have the prime contractor agree to you protecting your work only while you are actively working on the project, and have the prime contractor sign off on your project when your section is complete, instead of requiring you to protect your work for the entirety of the contract until completion and having to wait for the owner, architect and contractor or engineer or whomever signs off on it. So one of the things we recommend as a best practice is to keep a daily journal of your work with documentation and date stamped pictures. Any questions? Next slide, please. Okay. Indemnification language. So to indemnify another party is to compensate that party for losses that party has incurred or will incur as related to a specific incident. And it is to make them whole as if the loss had not occurred. That's the hold harmless. Indemnification, also known as hold harmless clause, is a duty to make good any loss, damage, or liability incurred by another. Indemnity has a general meaning of holding one harmless, that is to say that one party holds the other harmless for some loss or damage. As a subcontractor with a limited scope, you should review the indemnity language and attempt to limit whom you are indemnifying. If you are a subcontractor on a project without a design build scope, then it does not make sense to indemnify an architect, engineer, or similar design professionals. If there are problems with the plans and drawings, you do not want to be required to defend the plans. Always have your insurance agent, broker review your indemnification and insurance language to make sure that you have sufficient coverage. So where you can't modify the indemnification language, that's where you can step in and offset that risk with your own insurance. And I feel very passionate about indemnification language. I know it's not something that is exciting for other people, but I really want to make sure you guys protect yourself. Next slide, please. Okay. The key takeaways. There are 3 categories. Read your contract for accuracy, and this is where you have put together your estimate. You have given them a scope letter. Make sure your inclusions and our exclusions are in there. Make sure everything you agreed to and every discussion you had is reflected in the contract. The sections to review. Sections to pay close attention to. Go over those sections. And number 2, because of flow down provisions or incorporated by reference or whatever they want to call them, look at the impact. That means you need to get the general conditions. You need the specifications. Most of those for public works contracts are online. You can even download the RFP that the prime bid on so you can see what they agreed, what they were supposed to agree to, and that will help you with your insight into the contract. And I know we're talking about 500, 600 pages, which is why it's really important to understand the terms because they repeat. So if you're working in, I'm going to make up a place, New York City, every single time New York City Public Works Department puts out a contract, it's going, and the specifications, with few exceptions, they're going to say the same things. Once you've read them, you will get to know them better. Okay, number 4, what's really important is where you can negotiate, try to negotiate, especially when it's onerous terms or illegal terms. Number 5, when you are in doubt, get advice of a counsel, as well as soon as you can afford it, have that part of your best practices that a lawyer reviews all of your contracts. Next slide, please. Okay, so tips for contract review. Understand the contract, discuss strategies with your strategic partners. So understanding contract language is important. So if you understand the terms like termination for inconvenience or flow down provisions, it'll help ensure that all parties involved have a clear understanding of their rights, responsibilities, and obligations. Clear and precise language can also help prevent disputes, promote collaboration, and protect business relationships. It can also help you when you are talking to your program partners that work with you or your CPA or for any other person who is there as a resource for your business. Of course, tips, hire a lawyer to review your contracts. I know it's expensive. Understand boilerplate language. One of the things that's really important when you're having a 500, 600 page specification document or a contract is use Adobe search for terms. Once you know the boilerplate, then you're only looking for specific terms that could impact your business. Now, one of the things that we have now, and there's quite a few websites, is AI legal review. You can upload your contract into AI and they will do, they do a really decent job of putting it into layman's terms so that you can feel more comfortable understanding it. It's, you know, it's relatively cheap, and until you feel comfortable or find that the cost of a lawyer reviewing all your contracts is something you can afford, this is something you can do for yourself. Next slide, please. So what resources does Meriwether and William, the Hub Company, bring? We do assessments and targeted technical assistance. That means that people like me, as well as others on our team, are available to answer any questions that you have. We also offer field support services. We also offer surety and funding support services. Next slide, please. Now it's a Q&A section, and please feel free to take yourself off mute and ask any question that I can potentially answer.
I've just got one question. Are your notes included in this PowerPoint deck you're going to share with us?
I can do that.
That would be fantastic. I appreciate that.
Yeah,
Appreciate you. There's a lot of really good terminology, stuff that I have not really been exposed to. So
Yeah.
it's good information.
Yeah, we will. What we're going to do is we're going to send out the video as well as the slides. I'm going to put together a checklist and have them include that and send it out so you guys can kind of go through it. And then I will put together what I call a definition cheat sheet. But can you give me a week to put that together?
Oh, gladly.
Okay. Okay. Yeah. No.
Do you want me? Do you want me to put my email address in the chat, or is that something you've already collected?
I'm just for purposes of ease, I'm going to send it out to all the registrants. If you signed up, I have your I will have one of the team send it out to you. Yeah, I'm writing it down now. I have no problem. I think people protecting themselves and their contract is extremely important, and I will jump through hoops for that.
Yeah. If you ever give an in-person lecture in the area, I'd love to meet you sometime.
I would too. Where are you located?
San Leandro.
Oh, I give in-person lectures all the time at the County of Alameda.
Oh, well, you know, I've been trying to do business with the County of Alameda. You and I should talk.
We should. I will put my cell phone number in the chat and my work cell phone number in the chat. Or,
Thank you.
yeah. But I will be honest, I will not be responding today to anything else. But tomorrow I'm available. Okay.
Okay, is that any more questions? Last chance.
Next slide, please.